everybody could take their seats, we will be quite bound by the program today. All right, my name is Nicholas Smith. I'm the Dean of the Faculty of Law here at Stellenbosch University, and it really gives me great pleasure to welcome you at this Sports Law Conference organized by our Faculty of Law. We are very excited that you could join us today. We're very happy about the turnout that we have, and we wish you a very pleasant day as our guests. I'm sure that you might suspect that many academics are avid sport lovers, as you can see from this event. But in this instance, Annette had to act as a little bit of a conference researcher. And she informed me that amongst our attendees today, I'm not going to mention a lot of people, but I want to mention that we have some high performers here. For example, Skalk Brits. Skalk? There we go. Skalk, for those of you who don't know, was a member of the Springbok team that won the World Cup in 2019. And then we also are honored to have Fafa Knutse, one of our panelists, this morning as well. He also played 2 tests for the Springboks. So I have to say that for us as academics, this really adds to this event to have such athletes in the room. So a special word of welcome to all our athletes. Sports serve society by providing vivid examples of excellence. And our faculty recognizes that scholarly subject events such as this one benefit not only academia, but also society at large. We have therefore invested in several colloquiums, conferences, seminars over the last years. And this year alone, we have hosted events in the areas of criminal justice, children's rights, and labor law. This sports law conference will be followed before year-end still with one on 30 years of democracy and constitutional accountability. And already finalized for 2025, we have an international conference on small claims civil litigation, followed also by the 3rd installment of the Harvard IGLP Stellenbosch Global Scholars Academy that will take place in July next year. So we aim to continue investing in research and in social impact going forward. And I thank my colleagues for their enthusiasm and their dedication to organize these events to bring all of us together, as well, of course, as you, the participants. Because what is a conference without lively and interactive participation from the floor? Professor Louw, André, who is the main organizer of this event, together with Layckan and the team at the Department of Mercantile Law, alerted me to the fact that this faculty actually hosted a sports law conference in 2006 with Ali Bagher as the keynote speaker. That conference was a huge success, and we are therefore delighted to offer this installment, albeit 18 years later. So my colleagues have indicated to me that they would like to organize such a gathering on a much more regular basis. We are hoping to do so, especially because the conference call drew such a keen interest, and because Stellenbosch is undoubtedly a very appropriate host. I say that, having regard of Stellenbosch University's strong sport culture as institution, and we have Ilham Groenewald here today as well. Welcome, Ilham. As well as the developments in the wider town and our community. For example, the establishment of Stellenbosch FC, the first PSL club from the Cape Winelands district, and Stellenbosch University's rugby club, which I understand is the biggest club in the world, and also the club that has delivered the most Springbok players to date. As a final remark, in particular for our students here present today, but of course it holds true for all of us, sport provides profound learning moments. Successful athletes have shared many insights with us, such as to note your mistakes, learn from it, and then forget it. Roger Federer. Or that obstacles don't have to stop you. If you run into a wall, don't turn around, give up. Figure out how to climb it, go through it, or work around it. The famous Michael Jordan. It is therefore fitting, I think, that academics, practitioners, students, and others that are involved in sport gather at occasions such as this, to reflect and debate on how best to ensure the authenticity and also the viability of sport for the benefit of all, for society. I therefore wish you a very intellectually stimulating day, and I also hope that I will see many, if not most of you, at the IP Chair's annual public lecture tonight. Welcome and enjoy the day. I invite Professor Sadula Kajika to the floor. We just agreed that he will be the bad cop. I'm the friendly cop. He will do some household rules for us, and then thereafter the first session will start. Hopefully, we will follow the program rather promptly.
Thanks, Nicola. As Nicola said, my role is usually the bad cop. Just housekeeping, apparently this venue is only water consumption, so please don't bring in tea, coffee, or other beverages. I know people have maybe missed the sign, which is a bit subtle, but for the rest of the day, please no other beverages in this venue. My boss, Annette, it's not Nicola, it's Annette, will be keeping time for this session and all the sessions going forward. And so therefore I don't have time to make bad jokes or anything like that. I'm going to hand over to Professor Geo Quinot, who's going to explore the interface between sports and administrative law.
Sadula, André, thank you very much for the invitation to participate in this conference. You know, I've done a lot of conferences over the years, so as they say, this is not my first rodeo. But I've not been as nervous as I am today to deliver a paper in front of this crowd, so please go gentle on me. I did to appease, I hope, those very important people we've got in the room by wearing my South African rugby tie today, so please take that in note. And I'm pleased to see some familiar faces. I see Eugene at the back there, old classmates, so I'm gonna try my best. My topic is administrative law and sport, the re-survival of the jockey club. As a scholar of administrative law, that is that branch of the law that governs state administration, or bureaucrats if you like, I've often thought that there's no better evidence of the dominance of English law on South African administrative law than the so-called jockey club cases. The fact that the paradigm context in which difficult questions of the application of administrative law beyond the strict confines of the state administration is that of the jockey club of horse racing cannot be more English. If South African administrative law stood under the influence of Roman Dutch law, as so many other parts of our law does, this question would probably have emerged in the context of the Jukskei Club. When more than 30 years ago, in February 1993, a group of leading scholars, practitioners, and activists with a joint interest in administrative justice gathered at the Breakwater campus of UCT to deliberate on what changes needed to be introduced in South African law to achieve administrative justice in a democratic South Africa, the question of how to deal with the public-private divide was one of the core issues. The Breakwater document stated, "The need for a more participatory, enterprising, and caring administration will not only require voluntary cooperation with private individuals, bodies, and corporations, but also a continuing partnership between private and public bodies. This partnership requires a fundamental rethink of the dichotomy between private and public law powers and functions." The so-called Breakwater Declaration that was adopted by the participants following the workshop and that subsequently played a key role in reshaping administrative law and justice in South Africa recognized that public power is not only exercised by governmental bodies, but also by non-governmental private actors. It thus implicitly accepted that administrative law applies beyond strict governmental decision-making. However, the exact scope and modality of applying administrative law principles to conduct of non-governmental private actors remained, and I quote, an area requiring further consideration under the broad theme of the precise scope and implications of the public-private distinction in administrative law, end quote. In post-constitutional administrative law, and especially after the enactment of the Promotion of Administrative Justice Act 3 of 2000, PAJA, the treatment of private actors remains a challenging issue. The question of applying administrative law to private actors is enmeshed in a quagmire of technical and principled issues. These issues include the relationship between different sources of administrative law, particularly when it comes to the continued use of the common law, the concepts of administrative action and organ of state under the Constitution and under PAJA, and most pertinently, our understanding of public power and public function. This plethora of issues intersect with a plethora of contexts. These range from the role of private actors in fulfilling quintessential public functions. Think about the erstwhile Microfinance Regulatory Council controlling parts of the financial sector in the AAA investments case that has since morphed into the National Credit Regulator, to private actors operating in ostensibly non-governmental functions that nevertheless reflect characteristics of typical administrative powers. Think about the Advertising Regulatory Board in the Bliss Brands case, to private actors fulfilling non-governmental functions with considerable impact or power, but tenuous resemblance to typical administrative powers. Think about the General Synod of the Church in Gaum versus Van Rensburg. Sport is a particularly challenging context in this regard, since decisions in sport governance quite often can be categorized across all three these typical scenarios. In pre-constitutional administrative law in South Africa, it is thus perhaps not surprising that one of the leading strain of cases dealing with private actors in terms of administrative law-like principles flowed from a sporting context, so-called jockey club cases. These dealt with ostensibly private actors fulfilling largely private functions, but which were nevertheless subjected to administrative law discipline, or at least something approximating administrative law. This approach became difficult to square with post-constitutional administrative law, not least because of the narrow conceptualization of administrative action under PAJA. Several recent judgments have again engaged with the jockey club approach in different contexts. These judgments show that the issue remains unresolved, but very much alive. Thus, 30 years after the Breakwater Declaration, the issue of administrative justice in relation to private powers, such as sport governance, remains one requiring further consideration. In fact, I argue that we have moved further away from managing this issue in a satisfactory way since constitutionalization and the advent of PAJA. In the remainder of my time, I want to share with you this development since our pre-constitutional common law period to where we are today. The question remains, how should sport governance decisions be controlled by law? Firstly then, the jockey club and the common law. Before the Constitution came into operation, South African administrative law did not have any clear concept of administrative action. The application of administrative law was rather determined with reference to a host of different mechanisms. The dominant question, for the most part, was not whether administrative law applied, but what administrative law applies. The erstwhile classification of function systems served to determine whether specific rules of administrative law applied, in particular cases such as audi alteram partem, that is, the duty to give somebody a hearing before taking a decision, and forms of reasonableness, and then mostly only for the purposes of judicial review of such actions. It is notable that both Baxter and Wiggers, in their classic text on administrative law in South Africa, start their respective chapters on administrative action with a discussion of the classification of functions. Baxter, for example, explained, the courts have attempted to marshal the wide diversity of administrative acts by grouping them into a set of simple categories. It is within this rather open-ended approach to the application of administrative law that the Jockey Club enters the picture. Now, I refer to the Jockey Club, but of course, it wasn't only the Jockey Club that featured in this line of jurisprudence. In fact, the most important judgments, like Dornlaan Beleggings and Tron versus Ring van Willington, did not involve sport bodies at all. The Jockey Club was only such a frequent respondent in common law judicial review applications that it became synonymous with this area of the law. Common to all these cases was a challenge to a decision by an actor that did not form part of the state administration. The quintessential example was of the Jockey Club imposing some restriction on a jockey or a racehorse owner in some form of disciplinary action. For a host of different reasons, the courts at common law subjected these private decisions to review in administrative law or something akin to administrative law. That meant that such decisions could be challenged, scrutinized by the courts, and invalidated on a number of grounds. These included lawfulness, procedural fairness, and limited forms of reasonableness. In taking these actions, the Jockey Club or any other sport governing body thus had to adhere to the rules of administrative law in order to avoid their decisions being judicially invalidated. Sport administrators accordingly had to follow their own internal rules, their codes, their constitutions, their handbooks when taking decisions. If they failed to do so, their decisions could be reviewed on lawfulness grounds as ultra vires. Governing bodies, and particularly their disciplinary arms and structures, had to provide athletes and other members of their organizations with an opportunity to state their case before acting against them. And individual administrators could not participate in decisions in which they had an interest. A failure on any of these grounds could lead to a review of the decision on the rules of natural justice, for example, audi alteram partem. And governing bodies had to at least act rationally when imposing sanctions or adopting and applying restrictive rules, such as rules on registrations, transfers, and benefits, or risk having their decisions reviewed by courts on reasonableness grounds. The basis for such review was, however, not always particularly clear and certainly not uniform. One of the most common and seemingly easiest bases for review in these cases was contract. This was most often evident in the actual Jockey Club scenario. The argument was simply that the contract between the disputing parties, the club and the player, the club and the racehorse owner, incorporated administrative law-like protections into the relationship. Thus, in Turner versus Jockey Club, one of the most famous Jockey Club cases, the then appellate division held that, and I quote, "It is common cause that the relationship between a jockey licensed under the respondent's rules, such as the appellant, and the respondent is contractual, and that that relationship is governed by the respondent's rules and regulations, which constitute the terms of the contract between the parties and the applicable principles of the common law. In the case of a tribunal created by contract, the obligation to observe the elementary principles of justice derives from the express or implied terms of the agreement between the persons affected," end quote. Under this approach, the common law courts could insert typically by implication, administrative law principles into the relationship between the parties, as long as that relationship was contractual. And of course, the contract did not explicitly exclude such principles. The result was that courts could, for example, insist that sport governing bodies, and especially their disciplinary structures, afford athletes an opportunity to present their case before sanctioning them, or that governing bodies adhere to their own internal rules and codes in their own operations. Where no contract existed, or could reasonably be implied, things got a bit more difficult. For example, where a sporting body wanted to act against a former athlete. Here, the 1983 judgment of Goldstone J in Dornlaan Beleggings was particularly important. In Dornlaan, our court subjected a decision of the Johannesburg Stock Exchange, the JSE, which is a private company, to judicial review on administrative law grounds. In the complete absence of any contractual relationship between the parties involved. The basis for the review was partly the existence of a statutory duty on the JSE to act in the public interest, and partly the public function fulfilled by the JSE. While source continued to play an important role in determining the reviewability of the impugned action, Dornlaan opened the door in common law to a wider approach, in terms of which the nature of the power exercised also contributed to its reviewability. The constitutionalization of administrative law, and even more so the enactment of PERJA, drastically changed the approach to determining the scope of judicial review in South African law. Suddenly, everything turned on the constitutional and legislative definitions of organ of state and administrative action. On the one hand, these definitions explicitly confirmed the reviewability in administrative law of private actors' decisions. An organ of state, as defined, can be any other functioning or institution that is not necessarily part of the state administration. And an administrative action can be a decision taken by a natural or juristic person other than an organ of state. These could quite clearly include sporting bodies. On the other hand, the definitions complicated and potentially narrowed the basis for review of private actors' decisions in administrative law by requiring that decisions must amount to the exercise of a public power or a public function and must be of an administrative nature before they will amount to administrative action. The inquiry thus squarely shifted to the nature of the decision at stake. However, an overview of the many cases decided by our courts under the Constitution and PERJA dealing with this inquiry shows that this ostensible shift is more form than substance. Stating that a power or a function must be public in order to be subject to administrative law review does not in itself tell us which decisions are subject to such review. It largely just displaces the question, because now we have to ask, what is public power? What is a public function? Put differently, in every case, we must determine whether the power or function at issue is public in nature. The need for substantive criteria to answer this question remains. Our case law has been far from clear and consistent in identifying and applying criteria to determine whether a power or function is public. Early on, in the AAA Investments case, the Constitutional Court, and I quote, "In our constitutional structure, the council or any other entity does not have to be part of government or the government itself to be bound by the Constitution as a whole. The court thus focused on the nature of the council and the nature of the function it performs to determine whether its actions amounted to a public function subject to the Constitution. The court confirmed this fairly vague approach in AMCO, where it stated, quote, "The predominant focus is on the nature of the power being exercised. The question is not so much who exercises the power, nor even where does the power come from, but what does the power look and feel like? What does it do? And the court then provides us with some pointers in answering these questions, which include the source and the nature of the power, the subject matter, and whether it involves the exercise of a public duty. Decisions of sporting bodies have again been a key arena in which our courts have struggled with this inquiry. Like the Jockey Club of old, our courts have often had to determine whether the decisions of these private entities are susceptible to administrative law review under this new constitutional and administrative law regime. And the outcomes have been anything but consistent. In Cronje versus UCB, the well-known case where the UCB sought to ban Hansie Cronje for life from cricket after the contract between the UCB and Cronje had come to an end, the court held that the UCB was a private body and that its decision was contractual and not public in nature and thus not administrative action, with the result that the UCB was not subject to administrative law review in deciding to ban Cronje. In contrast, in Coetzee versus Committees and others, the court held that the National Soccer League, aka the PSL, is a, quote, body which performs a public function, ostensibly because, quote, soccer is a sport which enjoys large support, and the, quote, fate of soccer players is of public interest, end quote. I'm not sure whether we've got any soccer players in the room that will agree or disagree with that. As a result, the requirements, the regulations of the NSL pertaining to compensation, clearance, and transfers of players were subject to administrative justice. And the court subsequently invalidated the NSL's compensation scheme underlying transfers as irrational. In Turfu Raiders, and this is where my rugby tie is coming in, Turfu Raiders Rugby Club versus South African Rugby Union, the court held that decisions pertaining to the internal affairs of South Africa's SA Rugby Union would not be public in nature and thus subject to administrative law, but that decisions that have an impact beyond the union, such as on other clubs, their stakeholders, and, quote, the rugby-loving public, end quote, do carry public interest and are thus subject to administrative law controls. These included the decision in the present matter relating to determining the log positions of the teams to participate in the play of games. The court consequently invalidated SARU's decision on who may participate in the Supersport Club Championships in the season and ordered that the applicant club is entitled to participate in those championships. In National Horse Racing Authority of Southern Africa versus Naidu, that's now the new Jockey Club, the court was divided on whether disciplinary steps taken by the authority were subject to administrative justice under the Constitution and Perja, or only on common law grounds established in the old Jockey Club cases. Judge Wallace reasoned that he could see no reason for excluding decisions of sporting bodies from Perja's remit, noting that, quote, sport has a substantial influence in our society and can involve substantial sums of money, as well as exercising control over who may earn their living from involvement in sporting activities. Sport raises important public issues. Government has a substantial interest in sport, as evidenced by the existence of the Department of Sport and Recreation and the creation of the Sport Commission, end quote. And that these factors were particularly evident in regard to a sport, and I quote, of such long standing as horse racing, which involves very substantial sums of money and generates significant amounts by way of taxes on betting, end quote. He thus reasoned that a blanket exclusion of sporting bodies from Perja was not justified. The majority of the court, however, differed, stating that they have considerable reservations in regard to the issue of whether the actions of the appellant's disciplinary board can be described as administrative action and fall under the umbrella of Perja. And that, quote,
any change in the law, particularly one that classifies the disciplinary powers of the appellant as being the exercise of public powers, and therefore administrative action under the umbrella of PAJA, would result in a seismic shift in the state of the law, particularly as it affects the appellant's activities, end quote. Deputy Judge President Leveson for the majority further stated that it was not sure that the size of the sporting body and the extent of its commercial enterprise should be a yardstick to determine whether it exercises a public function or not. Persons who are members of less visible sporting bodies could justifiably claim that there would be a lurking inequality in that should be, and in that, if that should be the law's approach to domestic disciplinary tribunals. In my view, the judge says it is in the public interest that there be uniformity in the law's approach to these tribunals, end quote. The court subsequently subjected the National Horse Racing Authority's decision to sanction the appellant racehorse trainer to rationality review. And if all of these differences between the cases involving different sporting codes are not confusing enough, in Yorka versus Cricket South Africa, the court subjected the decision of Cricket SA to remove its president to administrative law review, pointing in direct contrast to the Cronje judgment to the public purpose to be served in protection of the appellant's rights because of the nature of power that Cricket South Africa exercises, the function it performs, and its role as custodian of cricket in the Republic and as the national controlling authority for cricket. The court subsequently invalidated the decision to remove Dr. Nyoka as president of Cricket SA on a host of administrative law grounds. Against this background of divergent opinions and very little coherence, the 2018 judgment in Ndoro versus Safa is notable for its attempt to bring some clarity. Ndoro dealt with a decision by the NSL, ostensibly based on FIFA's transfer rules, that Tenda Ndoro was not allowed to play for Ajax Cape Town during the 2017-18 season following multiple transfers. The matter landed before the SAFA Arbitration Tribunal, where the arbitrator declined to determine Ndoro's status. Ndoro and Ajax subsequently applied to the High Court to have that decision reviewed. The first question that Judge Unterhalter had to decide was whether the decision of the arbitrator, effectively as a functionary of the NSL and or SAFA, it's not entirely clear which one, was subject to administrative law under PAJA. He held that it was, pointing to the hierarchical and monopolistic nature of the control over professional football exercised by the NSL and SAFA and FIFA. Their explicit objectives to govern football in the public interest, including globally, and the court's view that, quote, the flourishing of the game is a public good, and one that is often understood to be bound up with the well-being of the nation, end quote. One must smile at the fact that the game does not have to be specified in this quote. The Ndoro judgment is important for several reasons. It analyzes our jurisprudence on judicial review of private actors, particularly sporting bodies, in terms of administrative law both before and after PAJA, with remarkable clarity and synthesis. Judge Unterhalter thus effectively cuts through the thicket to bring some light to this area of the law. Furthermore, the Ndoro judgment adopts an expansive approach to public power and public function when it formulates a standard of sorts to determine whether acts of private bodies are subject to administrative law review. This formulation obtains both negative and positive elements. On the negative side, the court stated that, quote, simply because a private entity is powerful and may do things that are of great interest to the public does not warrant the application of administrative law. On the positive side, the court stated that it is the assumption of exclusive, compulsory, coercive regulatory competence that secure public goods that reach beyond mere private advancement, that attracts the supervisory discipline of public law. Let me state that again. It is the assumption of exclusive, compulsory, coercive regulatory competence to secure public goods that reach beyond mere private advancement, that attracts the supervisory disciplines of public law. There are two key elements to this formulation. One, the nature of the function fulfilled. It must have a monopolistic or mandatory quality and must be of a regulatory nature. That is, it must guide behavior and operations in a particular context, a sector, or a field. The second element relates to its aim. It must be aimed at securing public goods. That is, goods that are not excludable and not non-rivalrous. However, securing public goods does not have to be the only aim of the action. The action may also pursue private advancement. It seems to me that this is quite a broad approach to public function, especially this public good element sitting alongside the private aims of the actor. I suspect that it will mostly be quite easy to argue that there is some public good hovering in the background of most voluntary associations' actions, especially sporting bodies. Finally, Ndoro is also noteworthy for the complete absence of any reliance on the contractual relationship between the parties as the basis for subjecting the impugned decision to a judicial review. Notwithstanding the acknowledged contractual basis of the relationship between the parties and the fact that one of the three bases of review argued by the applicant between the parties was in fact common law review of private power exercised by a voluntary association based on contract, the court paid no attention to this argument and rather engaged with the two alternative bases for review, PAJA and legality review. Ndoro largely brings the Jockey Club cases in under the scope of PAJA, but without using contract as a conduit to insert administrative law principles into the relationship. While the Jockey Club scenarios will, on this approach, mostly be dealt with as a matter of administrative law proper, a question remains as to the survival of the erstwhile basis of review in the Jockey Club cases, especially where there is no existing contractual relationship between the disputing parties. That is, common law review on administrative law-like principles. Applicants evidently continue to plead it, as Ndoro itself shows. It seems to me that 30 years after the Breakwater Declaration, our law is in greater mess when it comes to judicial review of decisions by private parties. The test or standard for determining whether those decisions amount to public functions and should thus be treated on par with actions of the state administration, that is, as administrative action, remains fluid, to put it mildly, or, as Cora Hoekstra has said, too much a matter of feel. Take the example of Ndoro and its premise that football is bound up with the nation's well-being and hence a public good. As Layckan of UCT rightly states, this does beg the question, what makes a sport a public good, worthy of public law protection? One might ask whether synchronized swimming, ping pong, or badminton would surmount the public good bar. And this is Lauren's quote, so if there are any synchronized swimmers, ping pong players, or badminton champs in the room, not my example. In the Ndoro case, we saw that Deputy Judge President Levinson questioned the equality of different legal treatment of sport governing body decisions based on the size and commercial heft of the particular sporting code. In any event, it seems to me that the approach to identifying such public functions has at times become so broad that almost all associations at least would take administrative actions reviewable under PAJA when acting under their own domestic rules. On the other hand, the approach to judicial review of truly private powers has seemingly become an unruly horse, to use another famous metaphor from our administrative law. There's clearly a need for controlling private power, and particularly private power exercised in collective settings such as sporting codes within our constitutional regime. This finds support in the Constitutional Court's comments in AMCO, where the court, for example, stated, quote, "The risk our Constitution recognizes and confronts is that patterns of exclusion and discrimination could be perpetuated through ostensibly private exercises of power," end quote. So, where should we go from here? Firstly, we have to be better at identifying decisions of private actors that should be treated as public functions. Where we find that a public actor exercises truly public functions, that is, a function that government would have had to fulfill but for that private actor, administrative law applies, full stop. And then, when we decide that private actors' decisions did not amount to a public function, we need to better understand on what basis it should nevertheless be subjected to review. This, of course, includes understanding the justification for such review. Such understanding must lead us in constructing the doctrinal mechanisms for review of private actions, including the content of those rules. That is, how the law expects those private bodies to act. I think we critically need to consider whether mainstream administrative law is the best horse for this race, whether in substance or form. Is it not time for the development of a proper area of law to govern entities such as associations, such as sporting bodies, whether major, such as SAFA, or minor, such as ostrich racing or Yukskei, but also other similarly positioned entities, like political parties, homeowners associations, religious bodies, etc., and the way they operate? I think the Supreme Court of Appeal's judgment in Advertising Regulatory Board versus Bliss Brands may be quite useful in such an endeavor. Without going into the detail, the court relied heavily on the constitutional right of association to review the board's actions vis-à-vis third parties. I think this is a promising lead, as we reiterate Breakwater's call for fundamental rethink of the dichotomy between private and public law powers and functions as an area requiring further consideration. This is also not to suggest that we should jettison administrative justice and the guardrails that the Jockey Club cases have developed in the context of sport over a long period of time. I think it is possible to use the right to administrative justice in Section 33 of the Constitution with a broader understanding of administration, to also include administration in the private context, such as administration of sport. Based on such an understanding, a fit-for-purpose regulatory regime can be developed alongside existing administrative law proper as we understand it today, that is, as applied to state decisions. Such a development will allow us to tailor the content of the law to the distinct context of private administration, without having to engage in fairly arbitrary and questionable categorization of private actions, such as decisions of sporting bodies, decisions of the Jockey Club, as somehow equivalent to state action. Thank you.
In respect of Geo's presentation, I think if anyone have a question, you can just raise your hand maybe. Yes, please, Jibben.
Thank you. Okay. Did you catch that? Great. So everything has to be resolved through private arbitration, and if that's not done, various sanctions can be inflicted. And again, in the footballing context, because this is where it happens the most, associations can be suspended from the mother body. And in some extreme circumstances, the entire exco can be expelled, and the mother body can impose its own exco. Now, my question is, how do we balance this prohibition on recourse to courts with the necessity for review? Because as you said, these private bodies do have the possibility of perpetuating negative actions privately. Thank you.
Yes, I think that's exactly the question. I think the point of departure in South Africa, at least, and this is what makes it so interesting, because this differs from country to country, and when you've got football, FIFA's involvement becomes the real interesting aspect. But in a country such as South Africa, where we've got rule of law, meaning that the constitution is supreme, that is the supreme power in the entire country above anything and everything, a provision such as autonomy and restricting disputes to domestic tribunals would always be subject to the constitution in the end, and that includes the court. So I think the point of departure is those kind of provisions and principles can only really postpone judicial intervention rather than replace it. That's the first important point. But that is an important point, because even in mainstream administrative law, you can go and look at section 7.2 of PAJA, our mainstream administrative law favors exhausting internal remedies in any context first before coming to court. And I think that principle is the same one. So, coming to your balancing question, I think the question then is that we need to develop, and what I'm suggesting at the end of my paper is not should we or should we not subject SAFA to courts in the end. That answer is answered. They are, right? So it's not a question. They are. The question is rather, what are the rules in terms of which they're subjected? So what is it that we expect of them and that we can test them on? And I think the problem at the moment is that we're trying to assess all actions, including actions of SAFA and the NSL and all the others, on the same basis that we use to test actions of municipalities and the Department of Home Affairs. And that's inappropriate, because we've got quite evidently a different interest in a municipality and Home Affairs' way of operating than we do in SAFA. And in my view, SAFA has got a greater legitimate expectation, I don't want to use that word because that's of course a technical word, but interest in a more closed approach, in being able to move more in a more agile way. So for example, procedural fairness, audi altrum parte. I would say as a kind of full-blooded administrative lawyer that audi altrum parte, procedural fairness in the context of SAFA should be lesser than in the case of the police or the Department of Home Affairs. So the trick for me lies in working out the content. And I think that's the work we must still do, and I think we're getting stuck because of these cases that's just engaging with the question, should we or should we not?
And thanks, Eben, for the question. I see Annette is smiling. I think, Geo, thank you. The timing was beautiful. And it's just, I'm not going to waste time, but I will just say, for me, it's just interesting when you open a law conference talking about how uncertain the law is. I think you used the word mess. And I think we're going to encounter a lot of that today, I think, as we go forward. So this is our first substantive session starting now. Michael Murphy is our presenter. I think if South African sports law knows such a thing as a dinosaur, it is Michael. He's been in the trenches for many years. I think, Geo mentioned the Committee's case. Michael, of course, instrumental there in acting for the player. Always very entertaining. I hope no pressure, but I think this will be interesting. And what I'm going to ask, and maybe to kind of set the scene for the sessions going forward, is that we have 5 panelists who will be serving on this in this session. And I'm going to ask the panelists to come up and maybe have a seat on the podium here while Michael presents, and then afterwards I'll give an opportunity for questions and discussions from the panel. Would the panelists prefer to stay seated where they are, or Okay, I'll just call you up after Michael's spoken. Thanks. You can see how well this has been planned. Eh?